Think suretyship and creditors' right. So sometimes a creditor might request a suretyship or a guarantor for debt of a debtor. Okay, so the creditor needs somebody's guarantee. Okay, so a guarantor or a surety is someone who agrees to stand liable for the debt of another person. Okay, so this is to ensure that there's a backup for the payment for the obligation owed by the debtor. Okay, irrespective of any of the collaterals, right? And as we know, as per the statute of frauds, suretyship needs to be in writing. So if someone is agreeing to be a surety, it needs to be better written and signed by the surety. Otherwise, court of law cannot enforce it. Okay. So let's see what is the difference between a surety and a guarantor. Okay. A surety is primarily liable. Okay. Surety is primarily liable, which means what? A creditor can directly go to the surety um, instead of going to the debtor. Okay, right away to the surety, right? So therefore, surety is primarily liable, right? Surety cannot say that, first the creditor has to go to the debtor and then try to collect it. If not, come to me. That cannot be an option for the surety because surety is primarily liable here. Okay, but a guarantor, on the other side, is secondarily liable. Okay, a guarantor or an endorser of a check, okay, um, is secondarily liable, which means what? If the debtor doesn't pay, that's when the creditor can basically come to the guarantor demanding money. Okay, so there are special forms of secondary liabilities in which a guarantor in last resort could be there, which means what? The creditor has to enforce all of his efforts for a collection. If nothing works out, only then he has to come and take as a last resort from the guarantor. Okay, so after all efforts have been exhausted, that's when the original creditor can come to the guarantor. As we said, as the statute of frauds apply, it needs to be written, okay, as a promise for suretyship. There could be two kinds of sureties. One is gratuitous surety, another is compensated surety, or we call it commercial surety. Okay, so gratitude surety does not take any compensations. For example, let's say a dad becoming a surety for a son. Okay, here dad is a gratuitous surety. That he doesn't take any money to become a surety for the son's loan, right? So therefore, he is a gratuitous surety. Okay, while a compensated surety is someone who is becoming a surety uh, for a compensation such as a companies bonding companies or something like that. They take money to become a surety. Okay, so of course they get compensated, okay, for their efforts. And a gratitude surety, he does not have any compensation, but his consideration would be the value that the creditor giving it to the debtor. That's the consideration that a gratitude surety gets. Okay, so therefore, a gratuitous surety will go free if the original creditor, does something to basically, um, you know, uh, basically do something that increases the surety's risk. Okay, any minor modifications in the contract can also leave the gratuitous surety free. But a compensated surety, okay, he does not go um, free if there are minor changes, but material changes in the contract, which increases compensated surety's risk of loss. Yes, he will go free. Now, what are the rights of the surety? Of course, they don't have much of the rights, right? They do not have much of the rights against the creditor. In the surety cannot ask for a notice. okay, or surety cannot ask, the debtor, so the original creditor to compel the collection from the debtor or apply the collateral, okay, because surety is primarily liable, all right. But of course, surety can offset any of the amounts that the original creditor owes to the surety. Let's say the original creditor had to pay $10,000 to the surety on a different contract. Okay, so if the debtor doesn't pay, he can obviously ask for offsetting this money. Okay, if this is the same, right? Now, what are the options for a surety against the principal debtor? One is called exoneration. Okay. So, what is exoneration? Before the surety pays the creditor, the principal debtor owes surety a duty to perform. So, surety may bring in a suit for exoneration for the principal debtor to pay. Okay. So, surety can compel the principal debtor to make the payment to the creditor. Next is subrogation. Okay, what's subrogation? Basically, now the surety, since after the surety has made the payment to the original creditor, he uh, somewhat like the original creditor to the debtor. Now he takes the position of a creditor. So now he would enforce every option that he has for the principal debtors, uh, obligations. Okay, so therefore, subrogation. Okay, the surety becomes the creditor now. Okay, surety becomes as if a original creditor. Now he has all the claims of a creditor now. Reimbursement. Okay, if the surety has paid the principal or the amounts owed by the debtor, surety will demand a reimbursement. Okay, from the debtor. Okay. Uh, Now this is called indemnification. Okay, reimbursement or indemnification. Okay. What ICE writes about co-sureties. In such cases, there could be situations where more than one surety is there. Okay, more than one surety is there. Okay, so each of the sureties might hold a liability of basically as the claim against the creditor, or maybe it could be, uh, separate liabilities. So, all the more, each of these sureties they are jointly and severally liable to the creditor. So, if a particular surety pays in excess of his prorated share, he can demand a contribution from all the others, depending on their legitimate shares. Okay, so if one surety pays the whole amount, he can demand um, basically contribution from others. Now, another one is, let's say surety is entitled to contributions from co-sureties for their share of the payment. Okay, contribution should be distinguished from exoneration in that right of contribution arises only after surety has already paid more than her or his share. If the contract does not specify the liability for each surety is liable based on a pro rata share determined by the solvent sureties. Okay, so that's really important. So, what are the defenses of surety? How can a surety escape from this liability? Okay, if creditor has instigated a fraud or duress on the principal data, surety can use it as a defense of not being liable. Okay, or the subject matter was an illegal subject matter. In that case, surety can, of course, use it as a defense of not meeting its obligations. Okay, such as the principal defrauded the 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 creditors, or the creditor has defrauded debtor to get into a contract, okay, by means of any fraudulent activities. Surety can escape, right, from his liabilities. Jurors, okay, threats, okay, if the creditor has used threats for the debtor to get into certain contracts, and if the surety did not know about the jurors, of course, he can escape, okay. Illegality of the subject matter again, as we said. Sometimes if the underlying obligations are paid by the principal debtor himself, okay, or he was ready, but the creditor doesn't accept it, he doesn't want to accept it. But if he's demanding money from surety, that doesn't work, because the original principal debtor was ready to pay, he was ready to tender his performance. So if the original creditor didn't accept it, the surety will go free. Or if the surety has become incapacitated, which means he was adjudicated insane. In such case, he can go free. Okay, or any lack of considerations. Okay, for example, as we said, um, if there has to be a consideration for a gratuitous surety. The consideration is what? The creditor gives value, okay, some kind of value to the debtor. Okay, so if just it was a promise, okay, and creditor did not provide any value to the original debtor, then of course there's no point in being a surety, right? A surety will go free for sure. Okay, um, and uh, variations of surety's risk, as we said, any variations in the contract, even if it is minor variations, that will leave the gratuitous surety to go free. Okay, he can escape the contract. Okay, extended time, if the principal debtor and creditor agree to extend time. For example, if the performance was to be done within 1 year, okay. Now later, let's say the creditor and debtor is agreeing to extend the contract for 3 years. Surety might, take this as a defense. Okay, he might go free. Okay, unless he's not compensated. Okay, so loss of a collateral. Let's say the collateral is lost. Okay, which was in the custody of the creditor. The collateral was lost. Okay, so therefore, the surety can leave free. Okay, the release of a held creditor discharges the surety for the amount of release, uh, for the amount of the value of the release to the compensated surety. Let's say, okay, there was a collateral for 50,000, okay, and the creditor released the debtor with a 25,000 collateral. Okay, so that much of liability will be released from the surety as well. Okay, or let's say the creditor releases a co-surety. As we know, all these co-sureties are severally and together they are liable for the uh, suretyship. If the creditor, okay, does a partiality and releases a particular surety, okay, all the others sureties would go free, at least to the extent of the the sureties amounts that he was being liable for. Let's say there was a 90,000 loan. Okay, there were three sureties, each taking 30, 30, 30. Okay, release of one surety, okay, is basically 33 percentage. Okay, so everybody will go to the extent of that percentage free. Okay, all the other sureties A, B, and C. If A is released, B and C will get released for the same amount. Okay, that's about surety ships. Okay, now we need to see certain Fair Debt Collection Practices Act, FDCPA, okay, which enforces abuses by the collection agencies in collecting consumer debts. Okay, certain prohibited acts, contracting the debtor on inconvenient timings. Okay, uh, if the debtor is represented by an attorney, okay, the creditors have to call up the attorney. Okay, they don't have any rights to call up the debtor. Making false or misleading claims, collecting the debtor at her place of employment and employer's objects. These are strictly prohibited under FDCPA Acts. That's about suretyship, guys.